Okay, well, I think I can now move on to introduce our next speaker. And our next speaker is Dr. Fernando Pasta Mercante. I hope I pronounced it right. I probably haven't pronounced it right. So
you did.
Who is Assistant Professor of Law at the IE University, the International University in Spain, a very distinguished university in Spain, where he teaches constitutional law, administrative law, and European Union law. He's researching into the field of European Union administrative law, special focus on state aid governance, dual bachelor's degrees in law and political science, and a master's of laws degree from Columbia as well, and a PhD in law by the European University Institute in Florence. Today, Dr. Pasta Mercante will be talking to us about possibilities and challenges of the comparative law methodology in legal education. Over to you, please.
Thank you very much. Can you see my screen? I hope you can. I would like, of course, to start by thanking the Chinese University of Hong Kong and the organizers of the conference for giving me the opportunity to be here today and to present my work in this very stimulating context. My presentation deals indeed with the possibilities and challenges of comparative law as a teaching methodology, and I want to stress the word teaching because, of course, the value of comparative law as a research method is well established, as proved, among other things, by the leading role that this methodology plays in large segments of legal scholarship, and the leading role that it also plays in many postgraduate and doctoral programs aimed at training legal academics. The Chinese University of Hong Kong, by the way, has an amazing center on comparative law, so I guess this is the right place to be talking about this. But I don't want to talk about the importance of comparative law in legal research. I want to reflect upon the possibilities and challenges that this methodology raises as a teaching tool, and to be more precise, as a teaching tool in standard legal education programs, by which I mean programs that do not specifically target would-be academics, but rather would be legal practitioners and professionals at large. And to be more precise, I want to reflect upon the possibilities and challenges that the use of comparative law raises in programs such as the one that you can see on the slide. Okay, so the kind of programs that I have in mind is for example, the dual BCL and JD program of McGill University, which introduces students into integrated or transsystemic teaching, and where the fundamental concepts of civil law and common law are studied from a comparative perspective. I also have in mind programs such as the LLB in Global Law offered by Tilburg University in the Netherlands, which is a bachelor program that goes beyond the limits of one judicial system and considers solutions from other jurisdictions or from international law, instead of studying law by reference to one single jurisdiction or to one national law only. And of course, I also have in mind the LLB in comparative law that we teach at IE University in Spain. So I am biased, completely biased when I talk about this methodology. I should maybe make this disclaimer from the very beginning. In our program, which by the way its official name is not LLB in comparative law, it's just LLB. We just take for granted that we use comparative law as a methodology. I just use the word comparative law here to stress what its content is about. We do teach comparative law and we apply comparative law as a methodology across all our courses. So I'm going to refer collectively to these kind of programs in my presentation as cosmopolitan legal programs. I'm going to use this word to refer to them. I am fully aware of the fact that there are slight differences between these programs, but I do think that they all have something in common, and what they have in common and what sets them apart from most legal programs across the world, I think are the three factors that I've listed on the slide. So the first factor, or the first feature that sets these programs apart from other programs is the fact that they do not simply offer some complementary courses on comparative law in their curriculum. Rather, what they do, or what we do, is we introduce this multi-jurisdictional approach across all our courses. I think that's the first defining element of these programs. The second element, or the second feature, is that within each of these courses, comparative law is the main focus. So we do not simply use comparative law to contextualize the domestic law of our own jurisdiction. When I teach administrative law in Madrid, in Spain, I do not use comparative law to contextualize Spanish administrative law. Instead, comparative law is the main focus of my course. Okay, so I think this is the second feature of the programs that I have in mind in today's presentation. And finally, and very importantly, and this is linked to what I said in the introduction, these are programs that have a generalist or a professional orientation. So the target of these programs or the purpose of these programs is to train students who may subsequently follow all sorts of career paths, including, of course, the practice of law. So these are not academic programs, these are generalist or professional programs. So these are the main features, or the features, the defining features of the cosmopolitan programs, cosmopolitan legal programs, to which I'm going to be referring in my presentation. Before going any further, I want to make a few disclaimers. The first one is that these are just 3 examples. I'm sure that I'm overlooking many other programs across many law schools throughout the world that adopt this very same methodology or this very same approach. So apologies in advance if someone in the audience comes from a law school which also has this kind of program and I haven't mentioned it. I would actually be delighted to hear about your own experience in the Q&A time later. The second disclaimer is that, of course, I come from a civil law jurisdiction and I've received a civil law training. For us, or from my perspective, this is something very novel. I think, or I have the intuition that actually legal teaching in the common law world, and especially in Commonwealth countries, is actually more cosmopolitan than teaching in civil law countries because of the common roots of many of the legal disciplines that are taught in these courses. But even in that context, I think, and again, please correct me later if you think that I'm wrong, I think that even in the common law context, legal programs normally do not go as far as the programs that I've mentioned, in the sense that there is still always a reference jurisdiction, which is normally the jurisdiction, the domestic jurisdiction of the country where legal programs are actually taught. And finally, I have to say that interestingly, some people say, some scholars say that even in civil law countries, this kind of cosmopolitan approach is actually represents a return to the origins of legal teaching. Because if we think of of how law used to be taught in the Middle Ages in the first European universities, so in La Sorbonne in France, in Bologna in Italy, in Oxford in England, or in Salamanca in Spain, what scholars used to teach back then was actually the jus commune, right, which was a combination of canon law and of Roman law, and the assumption was that law students would subsequently get acquainted with the specificities of their own jurisdictions through practice, right? But it was sort of taken for granted that the purpose of law schools was not to teach those specificities to students. Okay, so this is just some food for thought. I think it's an interesting point. So what I'm trying to do in my work, this is an ongoing research project, is to reflect upon the possibilities and challenges of this kind of cosmopolitan programs, and to do so from 3 different perspectives, which are obviously complementary. First, to think about the added value that these programs bring to students, of course, which are or should be at the core of any educational endeavor, the added value, but also the challenges or the problems that these programs have for them. As an instructor, as a professor, I'm also interested in reflecting upon the advantages and the disadvantages that teaching or that using this kind of methodology has for us, for instructors and professors. And finally, I think that it is also interesting to think about this issue from a more institutional perspective, thinking about the possibilities and challenges that these kind of programs raise from the perspective of universities or law schools as institutions. So what I'm going to do today is to simply go very quickly through these different angles and to share with you my initial ideas. Now, those are tentative ideas. Some of them are actually controversial. I'm fully aware of that, but I didn't want to miss this opportunity to share them with you. So let me start by saying a few things about the possibilities and challenges raised by cosmopolitan programs from the perspective of students. I think that the most important point to make is that the kind of trans-systemic or a multi-jurisdictional approach that I've described earlier can be very, very fruitful in pedagogical terms. And of course, this is an issue, this is a claim that would require a whole presentation on its own, and I don't want to focus only on this idea, although I think that it is very important, of course. I would simply say that it is possible to make the case that comparative law is a useful teaching method or teaching methodology, because it really helps students go to the core of the societal problems addressed by the law. It also helps them realize the contingency of most legal institutions and most legal solutions. And I would also say that it helps them visualize the sort of the values and the normative assumptions that that inform the law. If I had to summarize the advantages in pedagogical terms of using comparative law, I would probably say something along those lines. And to me, that's really the main advantage of these programs. Let me be clear about it, but I think that there are others. One of them, and I think it's important to stress this one given the topic of today's panel, is that cosmopolitan programs generally allow law schools to be more attractive for foreign students, and these may be an interesting instrument in making the legal classroom more diverse in at least in national terms. That's the kind of diversity that I'm talking about right now. And I guess one can also make the argument that given the multi-jurisdictional journey that students go through in these kind of programs, cosmopolitan programs prepare students very well for global practice or for international practice, if that's the career path that they want to undertake after law school. However, of course, not everything that glitters is gold, and I think it is also important to be aware of the fact that these programs have certain problems or certain downsides. One of them is the risk of sort of producing students who have a very shallow knowledge of a lot of jurisdictions and no specialized jurisdiction knowledge, of any jurisdiction in particular. And because of course there's a certain trade-off at play here, right? There is always this trade-off in legal teaching and in teaching in general. It's at the end of the day the trade-off between breadth and depth. Okay, so I think that's a problem we should all be aware of. And while it can be argued that that the lack of specialized knowledge is not necessarily a problem so long as students get a good grip over the essentials, so to speak, it can be a practical problem, or it can represent a practical obstacle when it comes to passing the bar first, or to accessing the legal profession, and to finding a job subsequently, because of the national or parochial dimension that most legal markets have, even if we live in a globalized world. And actually, many of the problems that I'm going to stress throughout my presentation actually stem from this fact, from the fact that whether we like it or not, there is a certain mismatch between the cosmopolitan worldview that inspires these kind of legal problems and the actual regulation and functioning of legal markets, which is still very much defined along national lines, even in the case of firms that specialize in international litigation and international transactions. Let me move on to the possibilities and challenge raised by these programs from the perspective of instructors, that is to say, from the perspective of professors. I'm not going to repeat here the pedagogical advantages that I've mentioned earlier, but I think they're also relevant here insofar as comparative law also facilitates the tasks of instructors in teaching their subjects to their courses to students. I would like to add some other ideas here. One of them is that from the perspective of instructors, engaging in this kind of teaching can allow them to reach a better alignment between their teaching and their research agendas. And of course, I don't want to put too much weight on this argument, because at the end of the day, this depends on the research agenda of each instructor. Not everybody does comparative law. But for those of us who engage in comparative law as part of our research agenda, of course, participating in these kind of programs is a very nice way of sort of better aligning our research and our teaching. So I think that's an important advantage. The other one, and maybe the most important one, is that these programs leave a lot of room for experimentation. And I think that this is something that enriches the teaching experience very much. I think that from the instructor's perspective, engaging in this type of methodology is definitely an opportunity for growth. And of course, I say this talking from my own experience, my own involvement in a cosmopolitan program of this sort. It is definitely an opportunity for growth, but it is also a challenge, among other things, because because this methodology requires a great deal of planning and some very hard academic choices that instructors generally do not need to confront in traditional legal programs. For example, when it comes to defining the reference jurisdictions or the legal systems that are going to be used throughout the course, or even the method of comparison that is going to be used to sort of approach those jurisdictions. These are problems that sort of instructors do not face in regular legal programs, and they are challenges. There are problems that they do have to confront when they partake in cosmopolitan legal programs. I also think that comparative law as a teaching methodology forces instructors to reconsider their standard teaching and evaluation methods, and I think that a good example of the kind of adjustments or the kind of adaptations that this method requires are the cases that most of us employ in our courses. And by case here, I mean the sort of hypothetical fact pattern that many of us use to train and to teach the skills of our students to identify, to formulate, and to resolve legal programs. Sorry, I got distracted. And so, excuse me. And so, in standard legal education programs, when we sort of design these fact patterns, we don't need to consider issues such as what is the reference jurisdiction, what is the legal system in light of which the case has to be addressed. But when we translate those methods to these kind of cosmopolitan programs, those are hard choices, hard decisions that have to be made. Finally, from the perspective of instructors, a problem with these programs is that because of their still relatively novel or marginal character, there are not many teaching materials available in the market. Of course, there's a lot of materials on comparative law, but these tend to be sort of research materials which are not sort of methodologically and complexity-wise fit for teaching, especially not for teaching in undergraduate courses, which are the courses that I have in mind. And finally, let me say a few things about the possibilities and challenges that this methodology raises from the perspective of institutions, and I will conclude with this. Before I say anything, I must say that I don't have and I've never had any managerial responsibility, so I speak with utmost caution when I address this issue. I think that one of the advantages, as I already said, of these programs is that it allows law schools to broaden their potential student base, which can be good in terms of diversity, as I said before. It also allows schools to broaden the diversity of their faculty, so not only of their student base. And I think that the combination of these two factors means that law schools may improve their positioning and their differentiation in the market, which can be good from many different perspectives, from a commercial perspective, from the perspective of rankings, etc., etc. I think that this can have some important advantages sort of down the road. But again, there are some important difficulties associated to these programs. The first of them is that managing this program is very complex. It's complex, or it can be complex, for example, to recruit the right faculty to teach in these programs. Not everybody is ready or willing to engage in this methodology, and I guess this can complicate the task of law schools management. More importantly, and to me these are really the two most important challenges raised by these programs, law schools may come across sort of regulatory obstacles when it comes to implementing implementing these programs, because the cosmopolitan approach that inspires these programs can fit uneasily with sort of higher education regulation and with the rules that govern legal programs in certain countries. Now, in my experience, just to give you the Spanish example, there is no rule in Spanish higher education law saying that law degrees should deal with Spanish law. But this is something that is sort of taken for granted by regulators and by supervisors. So it can definitely be a problem when it comes to having these programs approved. And finally, these programs can also be a problem from the perspective of having them pass an accreditation process or having them recognized by bar associations when it comes to recognizing their validity as a program that gives access to the bar or to the legal profession. And again, this has to do because of the mismatch between the cosmopolitan worldview that inspires these programs and the more national philosophy that is either implicitly or explicitly taken for granted when people think about legal education. So I've tried to squeeze my ideas and to be very fast so as to respect the time that was allocated to me. I hope that I was nevertheless clear. I'm going to leave it here. I'm of course looking forward to any questions or comments that you may have, either now or later. That's why I have my email on the slide. Thank you very much.
Thank you very much. A very interesting presentation, and we have got some questions for you. And you did keep punctually to time as well. I think I'm the only person who's overrun so far, so it's a good start to the conference.
You're the moderator.
Yeah, it's always. I think that's the prerogative of the moderator, isn't it? Always to overrun and be the one who does wrong. I should, by the way, just point out that when you were talking about medieval legal education, it did make me think again about that idea that a lot of people in medieval legal education, they would travel around, wouldn't they, between the different law schools to get some education in Paris, to move to Italy, to move to Spain. And I should mention, of course, that they didn't just come to England. From my past dean and my present dean, they did go to Scotland and to Germany as well, I believe, as well, for some legal education. So, yeah, it's an interesting thing that even when people were focusing on canon law, they would still go to different places at times to hear different experts on canon law, I suppose, as it was.
I think it's interesting, and it's interesting to think that back then it was taken for granted that law was a sort of a universal discipline, that it was not so important to teach it, to learn it or to study it in the context of the sort of the, well, those are sort of pre-national times, but it was taken for granted that it was not necessary to approach this discipline from the perspective, from a particular national discipline, but instead it was taken for granted that the purpose of schools was to teach sort of the essentials, the basics, I guess. And then for students who would later go into practice, they would sort of learn the specificities of their own jurisdiction through practice. It was taken for granted, interestingly.
And as we got time, I'll just, on a personal aside, I think that's a problem with my legal education. I really enjoyed my law degree, but it was very much because it was an English university that just taught really English law. There was very little in the way of any sort of comparative, anything else that was, and it was only really when I think coming to Hong Kong and then sort of again serving under a number of deans who've all been very interested in not just internationalization of the student body, but also because we've got a very international faculty here. So again, over 20 different jurisdictions represented in the faculty. One of the interesting things then is to talk to people from different jurisdictions.
Absolutely.
And I think that sort of opened my eyes a little bit to different things. So I obviously, having not studied in that way, I think it's a very different thing. So, but I've got a number of questions that have come in. So now I have to go to the questions for you. One is, from the student's perspective, is there research on why students choose these degrees? Because the issues regarding the profession, the bar exams, may not be relevant when students do not see that as their aim.
Well, actually, many students, I think that what drives most of the students who enroll in these programs is the desire to engage or to practice law in sort of international litigation or international dispute resolution context. To be honest, I'm not sure many of them realize how important it is in order to achieve that goal to still pass the bar in a specific jurisdiction. So many of them realize that when they are about to graduate, and then it becomes an issue, because this is something that you have to decide very carefully before you actually enroll in law school. Depending on the jurisdiction where you come from and depending on the jurisdiction where you want to practice, it may be easier or harder to pass the bar with a foreign law degree. And by foreign law degree, I mean here formally foreign. I mean, our degree, for example, is a Spanish Spanish degree, even if the content of the degree is not specifically Spanish law. So this is a very good question. This is still a problem, and this is sort of one of the problems raised by the mismatch that I was mentioning earlier between the fact that I truly believe that law can very well be taught from a comparative law perspective, but at the same time, I'm fully aware of the fact that legal markets are still organized along national lines. So we are sort of fighting against that, but that's a reality.
Okay, great. Thank you. More questions. And we have got time at the moment because I'm not sure our next speaker is with us. So I'll carry on with some more questions for you, if you don't mind. About the hard choices, most law teachers do not have deep knowledge of other legal systems. At best, they have some personal preferences based on language ability, short study abroad stays, etc. In light of this, is it realistic to envisage comprehensive comparative law teaching?
I think that's a very good point. We all have our own biases. I think that we all tend to sort of give priority to the jurisdictions that we know better, either because we have had some contact with them, or simply, as you say, because we know the language and therefore we have access to we can sort of have access to more materials. That's a very good point. I don't think, to be honest, I don't think it is realistic to present our teaching as universal. There are many jurisdictions I've never heard of, which may be very relevant and very interesting from an administrative law perspective. At the end of the day, I always end up relying on those that I know better. But again, this is partially connected to the fact, I think, that these programs are very new and still very marginal, and that's why there are not many materials on the market out there. If this became more widespread, then the problem would somehow be mitigated by the fact that more and more people would write about these issues, and so we would end up having a more, not a universal out view over all the jurisdictions that may be relevant in our courses, but definitely a better view of jurisdictions worldwide. I don't know if my answer makes sense.
It does, yeah, thank you. And again, carrying on, should all professors have complete freedom in choosing which areas or systems to consider in teaching, or should there be some restriction on the range of systems?
That's a very good point. I think that's one of the hard academic choices that institutions have to make, whether the reference jurisdictions, so to speak, or the reference legal systems, so to speak, are defined uniformly for the whole program, or whether instructors have freedom to choose the legal systems or the jurisdictions that are more relevant or more useful to explain the institutions of the discipline that they are teaching. In my law school, we do have a lot of freedom, I must say, but I understand why other schools would like to implement a more uniform approach across courses. Yeah.
Good, thank you. I mean, you mentioned in the faculty, I think we've got quite a strong representation of people who actually, research into comparative law. And
you do. I know you do.
And the other thing, of course, is that Hong Kong is an interesting jurisdiction in itself, because, of course, that's sort of, because so many transactions that occur in Hong Kong have an international sort of, at the minimum, they have a cross-border into the mainland sort of context. And so for practicing lawyers, again, I think there's got to be that idea, at the minimum, of an idea of conflicts of laws. So comparative law there, I think, is something that I think our students should be interested in. They should see the value of that, really, I think.
Yeah. Well, interesting, if I may add something very quickly. I've started my presentation by one example drawn from McGill in Canada, and then two examples drawn from Europe, Tilburg in the Netherlands, and IE University in Spain. And of course, the motivations, probably the motivations behind the design and implementation of these programs are different, right? In the case of Canada, the motivation is probably linked to the fact that in Canada, you have a coexistence between civil law jurisdictions in the French-speaking provinces of Canada, and then a more sort of common law approach to law in the English-speaking jurisdictions. And I guess that's the ultimate motivation behind the creation of that program. in Spain and in the Netherlands, probably the motivation has to do with European integration, with the fact that the European Union is driving a process of legal integration, which is bringing our jurisdictions closer. So I guess you can find different good reasons to do comparative law in different contexts.
So I suppose with Brexit, England will never have any comparative law. That will be the end of it, yes?
We'll see.
If it happens properly.
Yeah.
Anyway, I'm trying to see if we've actually got our next speaker with us, Lan Anh from Vietnam. I'm not sure if we've actually got our next speaker with us. Now, if we haven't, I'm afraid, let's just check on the lists coming through. Lan Anh, if you're there, please tell us. I know that I'm looking for Lan Anh. If Lan Anh is here, could you turn on could you unmute yourself? I don't know if Lan Anh is here because Lan Anh, is that you with your video on, but do you need to unmute? That's it. Is that you, Lan Anh?
Yes.
Hello.
Hello.
Very, very pleased to see you. Actually, I should say thank you first to Fernando again for a wonderful presentation and for filling in with a few more questions. It's great.